I will now like to invite upon stage the panelists for the next session by MCIA on strengthening Bangalore as the destination for dispute resolution. I would like to invite on stage Mr. KG Raghavan, who's senior advocate who's moderating the session, along with Dr. Harish Narasappa, senior advocate, Mr. Karan Joseph, partner at Shardul Amarchand Mangaldas, Mr. Nishanth Kadur, leader at Nisha Desai Associates, Ms. Poornima Hatti, partner at Samvad Partners, and Mr. Shreyas Jayasimha from Arna Law.
Good evening, everybody. I think we shall begin this last session on a very interesting subject, strengthening Bengaluru as a destination for dispute resolution. Many of us are hardcore Bangaloreans. So this subject has two aspects to it. One is, of course, the practicality of doing it, the advantages of doing it in a very objective manner. In other words, to objectively assess as to where Bangalore is in terms of being a destination for arbitration. The second, and I think it is a very important aspect because that contributes to the first, is our emotional connect to this city. The moment we have this emotional connect to this city, we will go all out to make it number one in any field. Today, Bangalore is the IT capital of the country. It is a very hospitable city. It is a burgeoning metropolis. You name the facility, you have it. It is by and large a law and order city. All boxes are ticked. And now we need to identify a few more boxes which need to be ticked for the purpose of making Bangalore as the destination for alternate dispute resolution. I have with me my co-panelists who are all very experienced in the field of arbitration. They have conducted arbitration not only in the city of Bangalore, but also in other cities in India. They have traveled abroad, conducted arbitrations there. So they will be able to give you a perspective of what they see in this city, which they don't see in other cities, what they see in other cities, which they don't see in this city. Therefore, you will have a complete perspective of how to make Bangalore the desired destination for arbitration. I have with me Mr. Harish Narasappa, who is a senior advocate, who has tremendous amount of experience in arbitration. I have Karan Joseph from Shardul Amarchand Mangaldas. I have Nishanth from Nisha Desai. I have Poornima from Samvad Partners, and I have Shreyas Jayasimha from Arna Law. I now invite Harish Narasappa to share his thoughts on how to make Bengaluru as a destination for dispute resolution. Over to you, Harish.
Thank you, Mr. Raghavan. I think the question clearly identifies that there is a problem. Otherwise, there wouldn't be this question or this discussion. So, I think more than trying to make it a destination for arbitration, which suggests that other people come here and try and resolve their disputes, I feel the initial task is to retain the work that we are actually generating in Bangalore. And there are enormous number of contracts that get signed in our city across various subject matters. Technology, hardcore commercial matters, venture capital, private equity, and you name it. Because there are so many different kinds of businesses that are now in the city. But what clauses are they choosing? Are they choosing Bangalore And the honest answer is Bangalore is not the first choice, even for people who are in Bangalore, and for a number of reasons. So I think the discussion, at least in my view, should be about how do we retain all the work that we're actually generating out of Bangalore and make sure that it stays in Bangalore and gets resolved in Bangalore. So for that, rather than trying to make it as a destination, which I feel should be the next step after we retain the work that we are generating here. If we look at it, there are 2 or 3 factors which I feel are relevant. One, if you do a back of the envelope calculation on the number of contracts that get signed on a daily basis in the city, and you can do it in one of 2 ways. You can either count the number of businesses or actually count the number of corporate lawyers that are in the city of Bangalore and how many contracts they're advising their clients to sign every day or every week. And then the numbers runs into thousands, if not more, every month. But that's not the number of disputes that we see in Bangalore. So what are the 2 or 3 factors that I feel we can make a change for the positive to retain these matters when they reach a dispute stage in the city of Bangalore? One, the biggest factor which I hear when people are not choosing Bangalore is the lack of original jurisdiction in our High Court. And even a Section 34 challenge, or if it's a pure commercial suit, it doesn't go to the High Court, it goes to the City Civil Court or the Commercial Division of the City Civil Court. And if it's a Section 34 challenge, then it goes to the Commercial Division of the City Civil Court and not the High Court. And that's a significant challenge. And that's domestically, if you're comparing to Delhi or Mumbai or Chennai, then that's a drawback that people talk about. So that's something I believe we can change. When I say we, I mean the legislature needs to change that, maybe by bringing an amendment to the original jurisdiction of the High Court and giving the High Court, at least on some pecuniary basis, that some matters go directly to the High Court in a Section 34. So that's one thought process I think we should pursue. Second, just in terms of the ecosystem around dispute resolution. So there are 2 or 3 sets of individuals and organizations that we need to focus on. One, the legal profession. And we have seen an influx of talent into Bangalore, primarily because of the expansion of law firms in Bangalore. So that's something we have benefited from the expansion of business in Bangalore. 2, the number of law colleges in the city of Bangalore, I think, is more than any other city in India. I think there are about 89 law colleges in the city of Bangalore. And then if you take Karnataka, there are a few more. So in terms of talent that is coming into the profession, we have enough. But how does that translate into the adjudicators, into the talent and pool of adjudicators? And that's something that we have to work on. And the third one is institutions. What kind of institutions we have to support both, because the topic talks about dispute resolution and not just ADR, but both in terms of the incoming talent, how do you prepare them to address challenges that are beyond traditional kinds of dispute resolution and traditional subject matters of dispute resolution, and in terms of ADR, what kind of institutional support can you give to both adjudicators and the lawyers who are arguing the matter. So I'll stop there with these comments and then come back maybe later.
Thank you, Harish. I think you've given us a very broad perspective of the issues that we need to address in order to make Bangalore as a destination for dispute resolution. And we shall take each of these as we get along with the other panelists. Poornima, what do you think of Bangalore as a destination in terms of the availability of soft skills, more importantly?
Thank you, Mr. Raghavan. It's a Pleasure to be here. I think the fact that the India ADR week has at least one day in Bangalore demonstrates that we're on the map. Neeti and I were having a conversation outside in terms of how do we strengthen this more, and why is Bangalore getting just one day and Bombay and Delhi are getting 2 days, and what more can we do? In the past 10 years or so that I have been back in Bangalore, the number of arbitration practitioners has definitely increased. Those of us who have chosen to make Bangalore home, as Mr. Raghavan said, we're not, relegating our practices only to Bangalore. We're sitting in Bangalore with arbitrations in different parts of the world and the country. So I think there has definitely been a movement towards that, and we then imbibe cross-cultural ideas to make sure that the competence of an arbitration that we run in Bangalore is equal to anywhere else in the world. So I think that talent pool and the soft skills that we have brought in through that definitely helps. Every day we get CVs to say we want to practice only international arbitration and be a part of your team, and we have to keep saying, no, but you still have to run to that city civil court, or you have to go to for your enforcement actions, and it just can't just be purely international arbitration. So I think in terms of that soft skill, we have moved on. What we need, though, is capacity building, if I may add to that. Harish mentioned that only a high court does not have original jurisdiction compared to Delhi. But I think while we wait for that amendment, and that's a good place to say to everybody, like Delhi or Bombay or Chennai, our High Court also has the original jurisdiction. I think we should start working on capacity building for our commercial courts and for our city civil courts. If you've looked after the commercial courts have come into play, the time taken by the commercial courts in disposing Section 9s and Section 34s has decreased. They are beginning to understand what arbitration means. They are beginning to understand what judicial support means. They are beginning to understand that they do not have to intervene at all times. 15 years ago, I remember I once went into the city civil court, and the judge was just overwhelmed with the kind of investment that was coming into through private equity into a tech company. That will be an aberration today. They do understand that the city is the Silicon Valley, it is the tech capital, that there is a lot of money flowing in, and they're more interested in helping strengthen the reputation of business in Bangalore. Of course, there is pressure from the government. The government is watching in terms of ease of doing business indices and all of that. So I think capacity building is really what I'm talking about, has to also happen. Lastly, we need a good pool of arbitrators. Recently, there was a pledge event in Bangalore. The few women arbitrators and arbitration practitioners in Bangalore met up. And all of us said, what more can we do? Can we get the High Court to appoint counsel as arbitrators? Why are we still relying on retired judges? Can we get them to talk more about women as arbitrators, and what more can we do? I think the fact that these conversations are now happening on a regular basis, and these conversations should then take some sort of fruition to lead to a good pool of arbitrators. I think the practitioners are already here. Thank you. I'll stop there.
Thank you, Poornima. I think that was a good insight. And of course, the advantages of having original jurisdiction to the High Court to decide Section 9 or Section 34, as opposed to having commercial courts, is a debatable issue, because the experience that one has in Bombay with the delay in disposal of matters in the High Court is something that is concerning, of course, but that's something that we have to debate in great depth. Shreyas has experience in dealing with arbitrations all across the world. In fact, he has represented India in several bilateral investment treaty arbitrations, and he has an office in Singapore. And it will be useful to hear Shreyas' view on how Bangalore compares in terms of arbitration infrastructure, etc., when compared with, say, what's happening in Singapore or London, as the case may be. Over to you, Shreyas.
Thank you, Mr. Raghavan. Namaskara. Um, I've been doing this, as you know, for 25 years, and I'm glad I'm not the only person from Bengaluru anymore. And but it still happens. It still happens in The Hague. It happens in other unlikely areas, and it should not happen. So the first thing I would say, and I always address people in the last row of any conference, so all the people in the last row, is that spread your wings. You have the skill sets. You should have the confidence to take on the world. And it is only in the mind. Absolutely nowhere else. The infrastructure that is required for global competition is internal. The external supports of an organization of public or private infrastructure can build. But unless you unleash that determination to accept that you are globally competitive, and that means you have the toolbox as an advocate that any international practitioner would be expected to have in London or wherever, New York, Singapore. You need to have that expectation of yourself. And then the world changes around you. So that's the first point I want to make. Second, as you can see, with more people making that choice, and I would say it's because of that and not an external factor, you see the external environment changing. I applaud Nick, who's here with us, Nick Peacock from London, but I also note the absence of almost every other, and I'm sorry, there are a few others as well from outside India. Thank you. Sorry, I didn't mention you by name, but the point I'm trying to make is that people are voting with their feet, even in India ADR week, not to come to Bangalore. It's not just the number of days. I have had so many emails come to me this week. I am coming to India. We'll be delighted to see you in Delhi or Bombay. And those emails are flying in from all parts of the world. So people are making a choice. How informed or not, the choice is a different matter. But the reality is that Bangalore, forget being a destination for dispute resolution, is not even a destination for a discussion on international arbitration. In fact, this gathering here is maybe a fraction of some of the gatherings we've seen in the past. So there is a dwindling number, and therefore we cannot take the early wins for granted. In terms of the infrastructure that can actually facilitate the growth, I think in the last panel and the feverish discussion around it, I do not think you would have seen such a panel and the discussion in Delhi or Bombay. There are some natural strengths. There are strong competitive advantages that Bangalore has. I think it would be best for us to collectively choose to focus on those strong competitive advantages. And it's typically in the knowledge economy. But the knowledge economy is not limited to IT. It relates to pharma, it relates to cutting edge, bleeding edge technologies, space. And there are several sectors where, as Harish said, the contracts are being written here, but the clauses are elsewhere. But for that, we need to earn our spurs. We need to earn the confidence of our clients that Bangalore can cater to their varied requirements. And finally, the point in infrastructure, I think if you look at the IDRC in London, or you look at the Paris Arbitration Center, some of us are shareholders there. Nick is involved as director of IDRC. Those are all private initiatives. There is nothing stopping a set of billionaires, trillionaires, or humble crorepathies to conceive of a fractionally owned state-of-the-art dispute resolution center. You have seen examples of this happen in other domains in Bangalore. Take, for example, art and the Museum of Art and Photography. It just took Mr. Abhishek Podar and his family to be determined to build this. They were asking for land, they didn't get it, they got it opposite the Venkatappa Art Gallery. But what they have built is globally recognized as one of the best art museums in India. Now, this is the kind of quantum leap that Bangalore should imagine and should create. And I think we have enough entrepreneurs and entrepreneurial lawyers amongst us to come up with a business plan to have a fractionally owned, privately owned uh, dispute resolution space. And I do not think we need to look at government or look at anyone with a sense of need. I think we know what the needs are. We just have to go out and build it. And I think that way we solve the problems for ourselves. And this is in keeping with the spirit of the energy of Bangalore.
Thank you, Shreyas. Now you have heard Harish tell us that in terms of drafting a clause, Bangalore is not far behind. You have agreements drafted in Bangalore, signed and settled in Bangalore, but having a clause for arbitration elsewhere. You heard Poornima tell us that we have the soft skills in terms of counsels and, of course, suggestions as to who should be or who should not be an arbitrator. That's a different issue. And we have Shreyas who told us that we need to have a mindset. These are very encouraging thoughts. But then, before we find a cure for the disease, we need to identify or diagnose the ailment. So I want to ask Karan to tell us what are the ailments that afflict Bangalore to be a favorite destination for dispute resolution. Over to you, Karan.
Thank you, sir. To begin with, I think the biggest ailment Bangalore has is that we're a young city. We've just started. All of this is fairly new to us as opposed to perhaps the traditional power centers of Delhi and Bombay. Now, of course, being a young city, perhaps people don't want to come here as often as they go to Delhi and Bombay. But I think the question that we must ask everyone who's perhaps looking forward to going to Delhi and Bombay is how many of them who visit India at these conferences in Delhi and Bombay have Indian-seated arbitrations? I don't think there'll be many. So the task that we have here is to make sure that we are a suitable destination for arbitrations seated in India. Now, for that, we need to have a conducive environment. To me, that is the legal ecosystem. Of course, much has been said about courts. I think the fact that we now have our commercial courts were really good and we've made great strides. Of course, it means that there's one more level because there's the commercial court, then the High Court, then the Supreme Court, as opposed to perhaps if we went to the High Court directly, right? So
Even when you go to the High Court, you will have possibly a single judge and a bench appeal
Correct.
within the High Court. So we are really not eliminating the number.
So the second part that we will have to work on is institutions. People are, or they take great comfort in having arbitrations administered as per the ICC rules, for instance, the LCIA rules, the SIAC rules. So we need to have a robust set of institutional rules. Then there is the infrastructure which you can split into physical and perhaps digital. I now honestly think physical infrastructure is not as important as it used to be, given the advances that we've made on the digital front. For instance, we have Teres here, which is transcribing everything that we have said. Teres is being used by the Supreme Court for their constitutional bench matters. But for some reason, it's from Bangalore, but it's not being used in Bangalore outside, I think, of MCIA and perhaps a handful of arbitrations. So transcripting, for instance, there are, of course, several others, is also something that we need to be focusing on. We need to focus on security. What is the data security that we are having with these institutions? There are, of course, 2-3 institutions in Bangalore. What security is there when I send them pleadings? Arbitration, after all, is to be confidential. Then, of course, there's e-filing, case management. Unfortunately, it's still somewhat very physical in that sense. The other thing is the training of arbitrators and training of counsels. I think we need to work towards making sure that we're able to showcase Bangalore as having the talent So that you have, for instance, a CIR come to Bangalore and have a training program here, right? How many arbitrations in Bangalore have valuation experts, expert witnesses, hot tubbing? Barely any. So I think all of these things we need to work towards to make sure that Bangalore is the preferred destination for arbitration.
That's a very good insight, Karan. Thank you very much. Nishanth, could you just tell us about what you think are the factors which deter having Bangalore as a place or a venue for arbitration, notwithstanding that today physical presence for arbitration might have become or has become less important.
Yeah. Thank you, Mr. Raghavan. I think some of these issues that I will be talking about have been briefly touched upon by the other panelists, but like Mr. Narasappa was mentioning some time ago, a lot of contracts are made in Bangalore. A lot of companies, and we have the kind of unicorns and really big companies operating out of Bangalore, founded in Bangalore, entering into deals running into millions, if not billions. But when it comes to drafting the arbitration clause, which is being done at the time, perhaps by a corporate lawyer, or perhaps even with some advice from a disputes lawyer, we see that, Bangalore is often not even considered. And I've been guilty of giving this advice once or twice. And I think one of the important reasons, right, and we did speak about, Poornima spoke about how commercial courts are doing quite well with all the capacity building that's going on, and how disposals are, very fast, and how, in fact, they have taken the concept of finality of awards very seriously. Sometimes, like a colleague at the bar was saying, too seriously. He was, of course, on the defending side of a Section 34. But how they are taking, these concepts very seriously. I think the problem is awareness. I think a lot of people, especially those not very well versed with how commercial courts in Bangalore are dealing with matters, would simply look at it as a black and white thing where, okay, if the High Court has original jurisdiction, it is very likely that I will have a better shot at getting what I want in the event of a dispute, rather than it being a lower court. And that mindset that trial court judges do not understand commerce, trial court judges do not understand arbitration, unfortunately, is there quite a lot, and that sort of needs to change. The second thing, and this is also something that keeps coming up, is what we have noticed is on the appointment of arbitrators in a Section 11 petition, for example. We see that the High Courts of Bombay and Delhi are a few steps ahead of us. That's at least my personal opinion, when it comes to the pool of arbitrators they choose from, right? So today we see that even our High Court, while deciding who should be the arbitrator in an ad hoc arbitration, often relies on the list prepared by our arbitral institution in Bangalore, which to the best of my understanding does not have too many lawyers names in it, zero lawyers, like. So there's not much choice or rather discretion that is being exercised, thinking about, okay, this counsel is perhaps going to be good for this dispute, why not appoint this counsel for a particular arbitration. And we're seeing this happen slowly but gradually in other high courts, and I think that's something where we're lacking. In fact, recently all of us know that the Chief Justice of India made a statement in court that he'd want young arbitrators to be appointed who could then be considered as to be elevated to the bench. So I think that's one more area that we should really looking at. I think I'll stop there, Mr. Raghavan.
Harish, you mentioned that even though contracts are drafted here, for some reason, the arbitration clause does not prefer Bangalore. Why do you think it is so in your experience? what is it that is deterring lawyers from promoting or pushing for Bangalore?
So I think there are 2 or 3 reasons from what I've gathered over the last decade or so. And like Nishanth, I have been guilty of not choosing Bangalore when I have advised clients on choosing on drafting commercial contracts. I think there are 3 or 4 reasons. One, compared to other cities, and yes, we have had a lot of history in Bangalore of construction-related arbitration, real estate arbitration, even before the liberalization era. But I think the initial set of businesses that came post 1991 in India, there was a lot of focus on customers outside India, led by the IT industry primarily, and then other knowledge industries. So in a lot of cases, they were being dictated to. I mean, they themselves were not in a bargaining position when it came to identifying governing laws and venues for arbitration or seats for arbitration. So they didn't have a choice. And then when the VC industry developed really after 2008 onwards is when the VC industry became big, and that led to a new set of contracts and clauses being drafted. And again, there was no, if I may add it, there was no combination, or rather, there's no the lawyers that were drafting these clauses were primarily corporate lawyers, and their awareness of the dispute resolution ecosystem is not as great as it can be. And as law firms have become bigger, the interaction between the corporate department and the dispute resolution department doesn't happen as often as it should. And arbitration clauses are one of the last clauses that are included in the contract. Normally, it's, I was talking to somebody else and they said, oh, it's a 3 a.m. clause, right? You just take the clause from the previous contract and you just add it in without really understanding and analyzing what are the issues involved in that contract and, which city do you need to choose, all of that. So that's the first 2 points that I wanted to make. The third point is, I think we really don't know much, at least the people who are drafting the contracts don't know much about the enormous advancement that people interacting between technology at the intersection of law and technology have made with Bangalore as a center. Now, there was an earlier panel discussion, I think, on ODR. All the companies are Bangalore based, and there are 2 or 3 more. And all of them are the only companies, I think, of all the ODR companies, organizations in India at the moment, I think there's only one that is not in Bangalore. There are about 5 or 6 that are leading the charge on ODR. And about, I think, except one, the rest are all in Bangalore. So there's no sort of embracing the advancements we have made in technology and using of technology for dispute resolutions across the board. So the traditional dispute resolution system, litigators and arbitrators have not really combined forces with the legal technology leaders. And partly because of the cost, and many of these legal tech platforms and legal tech solutions are sold to people outside India because there's more money available there. So I think there's a sort of a mismatch between availability of talent and ecosystem and embracing it and adopting it in the proper fashion.
There is one change which is perceptible between what it was, say, 15 years ago and what it is today. Even though Bangalore had large business houses, for the purpose of drafting contracts, they would invariably look at Mumbai or Delhi. But today, I think there is a change because those large law firms have offices in Bangalore with, if I may say so, local talent. And therefore, Indian business houses, Bangalore-based business houses are now looking at Bangalore lawyers, Bangalore firms to draft contracts. With that change, do you think, Poornima, we will have a better capability to include Bangalore as the venue for arbitration? And that initial drawback that was there where contracts were being drafted for Bangalore businesses outside Bangalore, I don't think anymore exists.
I think if we make a conscious effort, there's going to be change. And I think we do need to make that conscious effort. I mean, today, if I would take a considered view, should we write in, I mean, for the first time, actually, yesterday, we had a clause where the businesses were not from Bangalore, but the seat was Bangalore. So we were very, very pleasantly surprised. I made the team check again, and the clients were, and, they didn't have a real explanation as to why Bangalore was chosen. Nothing to do with Bangalore, but it was here. So I'm going to take that as a positive turn, despite no clear explanation as to why it was here. So I think with the maturing of the Bangalore legal market, whether outside firms setting up here or good homegrown talent in Bangalore, there is definitely going to be a change. And I think we just have to consciously write it in. I don't see that we're behind in any way. If it means that this results in more discussions, more conversations, we should definitely make it. Do we need another institution in Bangalore? Shreyas talked about a certain kind of institution. Karan also said a certain kind of institution. I know our court-annexed arbitration center has many problems, both in terms of space, people, a whole lot of things. But nothing prevents us from writing in the SIAC, the MCIA, the LCIA, ICC, wherever we want. So I don't think that is holding us back and shouldn't hold us back. The final thing is, why are we only comparing ourselves to Delhi and Bombay? Chennai and Calcutta were sources of commerce, with original jurisdiction. Nobody's writing Chennai in. Nobody's writing Calcutta in. So we've made some progress. Let's acknowledge that and pat ourselves on the back. We have moved. People are writing Bangalore in. Yes, we need to be ambitious. I agree with that. And say, why Delhi or why Singapore? Let's do it here. I think there is a lot of money that could come into Bangalore, which is going outside of India now, purely to make Singapore successful as a destination. There are specialist lawyers, specialist experts, all sitting in Singapore because they're adjudicating Indian arbitrations. Whether they are writing in Indian law or not is a different question, but those arbitrations are sourced from India. So I think there is definitely a market, and that could move back here, and we should definitely work towards making that happen. And perhaps at the end of this panel discussion, if there is a sort of a resolution to do so, it will definitely move the bar a little bit. Thank you.
You're right, Poornima, but why do we compare ourselves with Mumbai or Delhi? The reason is obvious. Delhi is a political capital. Mumbai is a financial capital. And if there is any other city in this country which can claim to be a capital, it is Bangalore, because we are the IT capital of Bangalore, of India. And we are the Silicon Valley of India. Now, having said that, there is one other aspect that's very important, and I request Shreyas to please enlighten us on that subject, which is the financial services market, which is becoming a very important area of operation for all businesses. And my experience tells me that the disputes between investee companies and PEs has increased tremendously.
So thank you. There are two parts to the question that has been posed to me, but let me take the opportunity to plug something in on the first part, which is on financial services. This is the time I call your attention to a book that very few people might have seen or picked up. It's a report of July 2024. It's a report of the expert committee for drafting institutional arbitration rules for another new arbitration center, God forbid. in the IFSC, which is currently notified in Gift City. Now, as part of that committee, what we did was we didn't listen to what the teacher asked us to do. While a client tells us to do something, sometimes you feel as a professional, they need to hear something else. So if you were to turn, if you're not distracted by the title of this report, you will find that inside it, there are proposals for a creation of a new international commercial court for an IFSC. There is no reason, in my view, why IFSC should be restricted to the state of Gujarat. The current election has shown us that India remains a very strong federation. There's no reason why Bangalore should not ask for a designation of a busy area as a financial services area under the IFSC Act. In terms of statutory reform, it has also been proposed to eliminate, for the purposes of the IFSC, the Section 37 appeal. So it will be shorter. And then there are sub-phases, but I'll jump straight to the most radical or perhaps the most commonsensical approach, which is to ask the question, does India need a new high court? Does India need a new high court? Do we need an elevator to advance our economic interests, or are the stairs enough? And it has been now written in this document that there is, in fact, there are drafted constitutional amendments for somebody who wants to critique it, or somebody who wants to consider it. But where will that high court be? I do not know. Will it be Gujarat? Will it be here? Will it be anywhere else? The point I'm making is simple, that we need to tune in to the moment that we have today in geoeconomics. Last time we saw it was perhaps in 2012. And we know what happened then. There was a couple of sovereign instincts to say, let's exercise police power on taxation and a few other topics. But now we need to see whether we want to seize this moment and create a new governing law that is fit for purpose. And that governing law can be India IFSC, which is delinked from India law per se. Some sectors might demand it. There is such great competition in the financial services sector, let's say in banking, even between London and New York till today. And there are, in fact, instances in our neighborhood, such as Singapore. Everybody talks about Singapore as a seat. But years before that, Singapore developed the governing law project. The governing law project was determined to make Singapore the governing law. Seat came next. The India governing law project will be complicated, but perhaps the India IFSC governing law project can be more directed. First point. Second point on your point about the PE disputes, I think that's separate from the financial services, but I would just draw one link between the two, which is fintech. Fintech shows the lines blurring between traditional insurance, reinsurance, banking, finance disputes, and the world of PE and the VC-backed global plans. Now, we all know that the innovators and the entrepreneurs who are drawn to Bangalore are, like the current Xanadu, is not for building a next app for Bangaloreans. Each of these people are trying to build world-beating business plans. They are birthing businesses for the globe, but out of Bangalore. And therefore, just that sheer ambition or that vision or the business plan will drive this bridge between fintech, touching IFSC or financial services, and the PE-VC world. Those disputes in the current environment will most likely go to Singapore, will most likely go to London. There's some competition back between London, wooing few Indian senior counsel, and thereby perhaps greater people from India and Indian clients to perhaps choosing London as a seat. But in that, Bangalore has an opportunity. But I think it'll have to be creative, and it'll have to use tools that are being provided, but it's for them to grasp it.
You mentioned about governing law. That's an interesting aspect of this. I think we should look at it a little more. Now, compared to, say, the United States, where each state has different laws, and your contract can say governed by the laws of New York, governed by the laws of California, governed by the laws of Delaware, whatever. We do not have that type of an issue in this country because we have a number of central enactments which invariably govern many of these disputes, excepting a few of these local statutes which may have a role to play. Now, given that, and the fact that we have such a robust business setup in India, Karan, what do you think is the reason why people or companies do not prefer Bangalore as a place for arbitration? Is it because the physical infrastructure generally is brittle? Bangalore has been bashed right, left, and center for the traffic problem. Similarly, are there other issues which stifle the growth of Bangalore? And is this Bangalore bashing justified?
I mean, I don't. My personal opinion is no.
Can't find a solution to the
I know
traffic problem.
that's true.
I
But then-
told you there is an emotional attachment to Bangalore.
So, which is why I'm not as guilty as Harish and Nishanth, because I have never sent arbitration outside of Bangalore. All contracts, I insist, can be Bangalore, at least within India. So I think that's, really, it gives us a bad reputation. And if you look at it, perhaps there are pockets that have these infrastructural, issues within Bangalore. I think where we all are, the centers of Bangalore, so to speak, don't really have those concerns. I think all of us that way are fortunate enough to be in and around the courts, and we don't deal with those issues. In terms of, but I'd rather focus on the pluses. If you look at any large city, all their infrastructure is stressed. So there's nothing really spectacular or something that makes Bangalore worse than another place. But what makes Bangalore better is, of course, the connectivity that it offers, the facilities that it offers, the fact there's also a cultural angle to it. At the end of the day, Bangalore is a very cosmopolitan city. And if you look at all the other centers, all the hubs, they are also cosmopolitan cities. So I think that does play, a big role. In terms of the last panel, anyone on that panel, could you imagine them as arbitrators on a tech dispute? Absolutely. And I do not see you getting a better pool than those 5 people perhaps anywhere else. So there are strengths that we have. And instead of focusing on the weaknesses, I'd rather that we advertise those strengths and show that we are a safe place to arbitrate. At the end of the day, any party that wants an arbitration clause is concerned with only one thing: enforcement. So as long as we're able to show that our courts are pro-enforcement, of course subject to exceptions, are pro-enforcement, I think we will go a long way. So for instance, so you brought out New York. New York has, apart from Section 10 of the FAA, the manifest disregard. It's so remote that, what you need to plead to get an award set aside. So I think we need to move towards that sort of regime. And I think we'll get there.
I really like the point that Bangalore is a cosmopolitan city. Let's compare Bangalore with, say, Chennai. I have nothing against any other city, but I'm making an objective comparison between Bangalore on the one hand and Chennai on the other. Or, for that matter, take even Mumbai. In Bangalore, am I wedded to my language the way in which Chennai is wedded to Tamil and Bombay is wedded to Marathi? I don't think so. You talk to a auto rickshaw driver in Bangalore in English, he will reply to you. You talk to him in Hindi, he will reply to you in Hindi. Do you have the same experience in Chennai? I can tell you it's not that way. Do you have the same experience in Bombay? I can tell you it's not that way. Therefore, the strength of Bangalore is its cosmopolitan character. We are all embracing. Now, how do you think, Nishanth, we can capitalize on the point that Karan mentioned about the cosmopolitan outlook of Bangaloreans?
I think, so just before I answer that question, on a lighter note, I think going back to what Poornima was talking about on how they found a arbitration clause that had no connection with Bangalore but had Bangalore as the seat. I'm just hoping it was not a 3 a.m. clause like what Harish mentioned, just take copy paste from an earlier agreement. And we do see quite a bit of that happening, 3 a.m. clauses.
If it is, then there's another contract which has binding hours.
It's more, so
which I guess is another positive development. But I think, so just to generally answer your question, there have been a lot of leaps already taken. Like Karan was mentioning, I think in terms of the judicial infrastructure, there's been a lot that has been happening in terms of enforceability. Something we didn't see 5-6 years ago, we're seeing now where, there's a clear demarcation made when it's an award as opposed to a judgment, and how awards are being given that sort of deference. Even in the first hearings, interim reliefs are being passed, etc. So I think we have come a little far in terms of judicial infrastructure. And talking about the cosmopolitan nature, something I mentioned a while ago, I think we have the big businesses, big industries that are already there, and contracts are already being drawn up. But what we really need to focus on is that last part on how do we bring, how do we convince lawyers who may not be very well versed with how courts function in Bangalore, that Bangalore is in fact a good arbitral destination.
But Shreyas mentioned that we should not look at government support for the purpose of promoting Bangalore. But Bangalore has had continuously over several years international conferences, international meets to attract investment. We have Invest Karnataka. That's a flagship program of the government of Karnataka, inviting business leaders from all across the world to come to Bangalore to invest. Now, don't you think, I leave that question open to anybody who wants to take it in the panel. Don't you think that Invest Karnataka should also promote Bangalore as a dispute resolution venue?
I'd say yes, of course, but we should understand that Invest Karnataka, in my view, is not at all as aggressive as many other state investment programs that I've observed from other states. And I don't think the orientation has yet arrived in any of these state invest programs to say that the dispute resolution center and its efficiency is a key part of a business decision when you look at the risk-reward matrix while you choose to have a location. So I think Invest Karnataka is got an opportunity, but it has to be perhaps educated that the opportunity exists. And I think that task lies on all of the people in this room.
So if I can add one.
Sure. Go ahead.
So I think there are certain subject matters or certain sectors, I think, where we can certainly push it. I mean, there are certain, not just government, but industry bodies, for example, in whether it's technology or biotechnology, those sectors, they're very active and very aggressive in luring people to the city. But they're also aware that the legal knowledge in those sectors is better in Bangalore than most other parts of the world, and not just other parts of India. You have people sitting in Bangalore who are very good in law relating to technology, and they compare with anybody else in the world. So I think there may be an opportunity for us to showcase these strengths that we have that don't exist in many other parts, even when it comes to dispute resolution. That may be one way forward.
I know the monitor tells me time's up, but we started late. So I will take the liberty of winding up this panel discussion in the next 5 minutes. Now I just want to make 2 points. and I leave it to the panelists to take it up. One, why is it that there is a perception that judges sitting in Delhi or Mumbai are more commercially savvy than judges sitting in Bangalore? Point number one. Second, is that perception right?
I'll take it at the risk of being contrarian. I think it's true. Let's not kid ourselves when we say that a commercial bench of the Delhi High Court is more commercially minded than Bangalore. I think it's changing, but the fact is that they are more commercially minded. So also of Bombay. Of course, Bombay has its delays, which it's taking away. Maybe even in Chennai, I think the judges of the High Court are more commercially minded. Simply because traditionally our judges have not practiced commercial law. We probably are the first or second generation of commercial lawyers. Earlier, the focus was something else, whether it was land reform, tax, something else. So if you haven't practiced and done that work, you obviously cannot be expected to be commercial minded. Are they learning? Are they open to ideas? Of course they are. So I think that's where, when I said the commercial courts are doing a great job, I think there is some investment in terms of their training. They're conscious that they're being watched. Bangalore is one of the cities that is being watched by the government for ease of doing business. So they do keep to their timelines. They are learning. They are open to ideas. So I think it will change. But as of now, yes, that is something that is concerning. If our High Court starts appointing non-judges as arbitrators, it will definitely be a step forward. I think that's easy to achieve. They may maintain a list of non-judges as arbitrators. Maybe small matters start. If the Supreme Court is doing it, why can't we do it? Maybe they can then reach out to other institutions and start it. The second point that I wanted to make is, of course, we need the government, in my opinion. The SIAC has not arrived on the scene without the support of the Singapore government. The Singapore government has put in time, energy, money. At every SIAC conference, the Chief Justice of Singapore still comes to India. The Minister for Law still comes to India. They will come wherever they need to do to make sure that the SIAC continues to remain relevant. And Singapore is a tiny city. So if we want to have a patch of that, we must involve the government in whatever form, whether in West Karnataka or somebody else, and take that buy-in and say, look, we're building something, be a part of it in whatever form you want to do that. So I'll stop there. Thank you.
Do you think, I just want to put a last question and then we'll leave it to the audience to express their views. Do you think that Bangalore being deprived of offices like the trademark registry, the patent office, the operating office for SEBI, decision-making body of the RBI in Bangalore, these are all contributing to making Bangalore less attractive?
So I think to expect Delhi and Bombay to suddenly defer space to Bangalore is unrealistic and it will not happen. Bangalore must realize its own place in the world on its own feet, not relying either on the state or the central government. Our biggest strength is our people, is our energy that we've attracted here. As you said, the cosmopolitan. For 21 or 22 years, we've voted as the #1 place for foreigners to live in India. This is our strength. We don't need any of these, any governmental interference at all. In fact, to press home the point and to clarify what Poornima had thought I'd said, I'm not advocating the creation of a new institution, God forbid. No, I'm saying create an ecosystem, even a physical ecosystem. Like Pramod here has been instrumental in bringing the permanent court of arbitration into Delhi. International institutions, when they're located in India, why not Bangalore? Why not other places? We've had the ICJ India chapter here for the longest time. Similarly, we need to create the infrastructure, create that ecosystem of ideas and the ambition to take these to action and fruition. And that's where I think our strengths lie. Expecting domestic bodies to be located here is going into the realm of politics, which is our weakness. We are always contrarian in our political outcomes.
Thank you. I think that's opened up a wide range of issues which have a positive impact on making Bangalore as a destination for dispute resolution. And now I invite the very learned audience to have their views on this very important subject.
He is suggesting that we are out of time, so no, no opportunity.
Oh, yeah, okay. Yes, sure. Any questions, or do you think we'll oblige Niti?
If there are no questions, maybe you can do a poll to say.
Yeah, go ahead, go ahead.
Since nobody's talking, so I thought we asked.
Sure, sure.
Sir, I just want to say to everyone.
Yeah, I can use that, please. Okay.
I must say I came late, so my point is something totally different, or rather I could catch whatever I want to say. Sir, about 20 years ago, I'm sure you are also at the bar and many of us are here. When we wanted an important matter to be argued, we would get counsel from Chennai. Now, it just doesn't happen.
It's the other way.
Maybe.
So, there is a lot of hope, and today we've got very good judges, and I don't see in any way, of course, I do agree that lack of patent office, lack of SEBI office, or all things that you said is a huge contributor for Bangalore not being the commercial hub in the 90s. That should have happened in the 90s. So that's, I think, we did miss the bus. For example, I didn't practice in patent only because every time I had to go to either Chennai or Mumbai. So I know many people like me did not do that. So having said it, sir, we are on the high rise, and it's only a matter of time that we will be the #1 dispute resolution center in India.
Very good. That's good to end on a very positive note. Thank you very much, everybody. I thank the panelists for the very valuable contribution they have made and the insight that we have had into this very important subject. And I thank all of you for giving us this very patient hearing. Thank you once again.